say particularly that there would be one kind of case or another that I wouldn't want to do on Zoom. I mean, obviously, as was emphasized in the program today, I think everybody participating prefers the in-person setting, and certainly I do as well. But I think it's got to be kind of client driven, because if there's something that needs to get heard, it just needs to get heard, whether it's complicated or not complicated. I mean, that's kind of my view on it, that we really just can't push things down the road unless, you know, the parties mutually agree, okay, we'll just put this on ice for who knows how long.
Thank you.
Yeah, and my view has kind of evolved over time here. So when that was recorded, we were still very early on. COVID had, you know, I think it was around for about a month. At least people were isolating for about a month at that time. And no one at that time thought that come September 30th, we would still be in this kind of situation. As times progressed, we've become more open to doing labor arbitrations by Zoom. We've done them. They have been very effective, and there's no end in sight now. When previously, like when this happened in March, I could have told, pretty confidently, I would have felt that by June or July, we would be able to get back and have an in-person hearing. But now that's not the case, and there's no real deadline in sight. So my view has evolved, and I am much more open to doing it, in part because things need to get heard, and there's no end in sight for this. And also, as I've used the technology more and more, it really has been an effective way to resolve grievances.
Renee, we can't hear you. Are you muted?
Yeah.
There we go. From my perspective, the most important issue is how the advocates feel about the video conference hearing. As both Patrick and James have said, early on, it was something new. It was, we were all trying to, figure it out, how to make it effective from a hearing standpoint. And now, usually either the parties come to me when they select me, they'll tell me that they have agreed to a virtual hearing, or they have agreed that they have to have an in-person hearing. And so I leave it up to the parties what their choice is. However, on occasion, as I had last week, where after a hearing had been rescheduled 3 times to have an in-person hearing, and we had established the protocols for the in-person hearing, one of the advocates decided 2 days before the hearing that that person did not want to attend an in-person hearing. So I held a pre-hearing conference to attempt to work through it. And then eventually that advocate came around, but it took a few days to work through, how could the person be at another location and ensure that there weren't ex parte communications, or just trying to work through what the person's concerns were. So I can't say with confidence that wouldn't happen again, but the pre-hearing conference and then any necessity to work through the concerns that the advocates have is what I consider paramount in my decision whether to move forward with an in-person or a virtual hearing.
In your last example, I just have a question. In your last example, did the parties agree to the remote hearing eventually after you talked with them?
No. Eventually, it was as had been planned from the beginning. This was a law enforcement termination case, and it was, those are, as you know, as advocates and as the people viewing this, these are very complex cases. And to attempt to do it virtually, it certainly can be done from my perspective, but it's the advocates that have to make that decision. And so in the areas that I have held in-person hearings during the pandemic, I've checked what the public health orders were. I worked with the advocates as far as what they needed to have an in-person hearing and made sure that it was as safe as we could have. But issues come up. And for this particular advocate, an issue did come up 2 days before.
Thank you. I'll move on to our next question. So what would be a few of the key things you would require when you are conducting a video arbitration?
Well, I'll answer that first. From my perspective, I do want a pre-hearing conference, and I want to discuss with the advocates what they want as the ground rules. And so I'm working with them. I have a list of suggestions, but this is their hearing. And so I want to make sure that they have mutually agreed upon what the ground rules are and that I'm comfortable. The second issue would be the platform. If they want me to host it, I want to, in the ideal, I want a court reporter, because if I am moving people around, watching out for any concerns and watching the witnesses, taking notes, it is burdensome. It's a big job to do all of that at the same time.
Well, when or why would you absolutely not agree to conduct the video arbitration? Any of you?
I can't think of an example right off the top of my head, quite frankly, at this point in the pandemic. As I said earlier, I think it's really going to have to be the call of the clients. If they believe that whatever this issue is that can be postponed, can be postponed. Otherwise, we need to go forward with the process that we have available to us.
Yeah, I'd have to concur there. Again, if it's a major contract interpretation case, and I think Patrick agrees, it'd be ideal to do it in person, but we take our clients' lead as well, and it has proven to date to be an effective way using Zoom to hold these arbitrations. So I guess it would only be if the client has a very strong reason not moving forward with it, then I would push back on it.
And for me, if I have a front page of the newspaper case, especially a law enforcement case, one that has had national news, and the advocates are hesitant, I would encourage them to consider an in-person case. If they want, again, I go back to my view that this is the advocate's decision. If they want an in-person, if they want a virtual hearing, then I will conduct it.
And one happy medium that I've struck recently, as New Jersey has opened up a little bit more and more, is being actually in the same room as my client and my witnesses. Now we're able to, effectively do that. So although the hearing's still remote and the arbitrators in one location, the unions in one location, it's helpful to be present with my client and my witnesses. So that's one way I've been able to strike a happy medium.
James,
I was just going to say, that requires some special equipment, though. You just can't have a laptop in the room with your clients and then be passing it around. You've got to make sure, the audio is off so you don't get feedback. So a video remote arbitration that I did a month or so ago, the company lawyer actually did travel from out of state to meet with his clients in Tennessee, and they were all in a big conference room, and they had a giant camera and video screen there. So I was able to see the lawyer and the witness who was in the room with him during their testimony. The arbitrator was in Dallas and I was in Houston. I had my client in my office, but I had him in my library with the door shut, and then I was in our conference room with our door shut. So doing what James suggested, I think is good, but you got to have the right setup for it.
I was just going to say that it also requires an extensive amount of space to ensure both meeting the public health orders as well as avoiding wearing masks during the video conference hearing. And so as the arbitrator, I want to see the witnesses, I want to see their faces. And so when I have an in-person hearing, I ask for 12 feet. Now, I don't often get 12 feet when I arrive. However, I get there an hour early so that I can move chairs and tables around with the advocates to make sure that we have as much space as possible. Because again, in the case like I just described where there was an advocate who didn't want to come, we were trying to discuss how we could set it up in a way that he could have his grievant and witnesses on video at the same time he's in another state. And in the end, he decided to come. But it's all about planning. I thought the video was very well done here, in terms of the two advocates and the moderator, in terms of discussing, setting up your ground rules and figuring out in advance, to the best of our ability, how to avoid the glitches that could happen on video conferencing, because they do. I mean, it just simply happens, and how to deal with those in advance to the best of our ability.
Thank you. So our next question is going to be one aspect for each of our panelists. What can each panelist do in a video arbitration hearing to either evaluate the grievance credibility as an arbitrator, or improve the grievance credibility as a union advocate, or detract from or destroy the grievance credibility as an employee advocate?
Well, I had a video arbitration 2 days ago where the grievant kept disappearing from view. And I stopped the questioning of another witness, and I would direct the grievant to get back in the video. And by the time the grievant testified, and clearly he was a reluctant witness, I haven't assessed the credibility yet, but nonetheless, his credibility. But nonetheless, it was difficult. And so again, despite setting the rules, the arbitrator has to manage the hearing, whether it's in person or it's on video. And on video, all sorts of things could happen, like there's the grievant disappearing again, And so I give the advocate a moment to see if she or he will say something, and if they don't, then I'm going to say, you have to get back in front of your camera.
Now, from the union side, I think it's going to be the same from the employer side. You want all of your witnesses to, be credible and appear credible. But, as I said earlier, the more experience you have with this, the more I question whether this credibility issue is such a big issue with regard to the video. I mean, I think traditionally arbitrators determine credibility based on all the witnesses' testimony and the exhibits. Do all the witnesses contradict one another? What do the exhibits look like to corroborate one over another? I think that's more important in the mix than the witness's appearance on the video screen. I just think it's being overemphasized and overplayed. I mean, I may be wrong in a particular case or another, but that's kind of my thought. But just from an appearance standpoint, in the video arbitration or remote arbitration that I did a month or so ago, my grievant brought his laptop up. And of course, we did the experimental prep as recommended by James and his colleague, as we saw in the video today. And I noticed that his camera, it just had this kind of a orange glow or tint to it. It just didn't look good. So I ended up having to loan him one of my computers to testify at the hearing. And another good point that James made in the video today was, backlighting. So I think, the lawyers need to check all that stuff out as part of the preparation for going live.
Any response from the employer side, James?
Sure. I'll just add that to Renee's point, being very cognizant of of the grievant, and if there is a situation where he or she looks distracted or diverted, to be on top of that to make sure you can address it. To Patrick's point, that may not occur very often. But it's something to definitely keep in mind. Other than that, the ways for addressing credibility is, as an employer advocate, is to know the facts better than the grievant, and to know your exhibits better than the grievant, because inevitably or frequently, grievants, if they're not telling the truth, are going to be tripped up, and you're going to have evidence to point that out, which is going to be the situation if you're in person or remote.
Thank you. And if we could just get one answer to 5 and 6, as we're running short of time and I have several questions left. What would you say the keys to effectively handling exhibits in a video arbitration would be, one of you?
Well, I know James is real comfortable with the on-screen sharing. I can't say that so much for myself, but it may be just lack of experience than anything else. I prefer sending the exhibits hard copy to everybody. And of course, that does, leave a little bit to be desired if you've got that, surprise exhibit that we have from time to time in arbitration. But, we have to kind of go with the system.
Understood. And number 6, what do you see as the future for video arbitrations after the current COVID-19 pandemic? One of you.
I'll take that. Just as 9/11 changed how we air travel, I believe that the pandemic has changed the world of work. And I do see the future of virtual arbitration as another tool in our toolkit to resolve, whether it's contract interpretation cases, disciplinary termination cases. I believe that we've added another option to labor management relations through the pandemic.
Thank you. I agree with that. We have a lot of questions left and only 4 minutes, so I'm going to get to at least 2 more. Angela De Silva wanted to know, how far in advance is a pre-hearing conference?
I will just say that whatever the advocates want. I mean, I would like it earlier, but I've had it, like on Monday, I had it a half an hour before the hearing started. That's just the way it worked out with the advocates. So it's really up to the advocates. The earlier, the better, so parties get to prepare. And in that case, they didn't have their all of their documents submitted to me. So, you know, I had to work through that with them as well.
Thank you. And Jeanette asked, what did the advocate screens look like during the hearing? Did you use gallery view or speaker view? Was it possible to dedicate a second screen to screen sharing exhibits?
I use gallery view.
And I spotlight the advocates, myself, and the witness. So each time there's a new witness, then unspotlight the previous one, spotlight the new one. So I have 4 tiles up on my screen.
And I would just add that 2 screens would be preferable to 1 if you can do that. And I also have a preference if I can have an associate attorney handle the arbitration with me, so they could focus on putting the exhibits on the screen, for example, while I'm focused more on doing the witness examination.
Understood. So Mickey, we have about 2 minutes left and a number of questions that we haven't gotten to. Should we go ahead and wrap it up?
Let's try another couple of questions. Try 4.
Okay. So another question, how important would it be to have a technical assistant to specifically handle the Zoom system operations versus the arbitrator, court reporter, and the advocate doing double duty? And who should pay for that technical assistant? That's a great question.
Well, I'm proficient on Zoom. I got my first computer in 1984. I've been riding the technology train all along. I would not ask for a technical assistant, but if the parties want to provide one, as sometimes the case, I welcome it. It is always my preference to be the arbitrator rather than the technician in an online hearing. And who pays for it? It's up to the, if the advocates want it, then they pay for it.
Okay. Well, thank you,
Just
everyone.
do a lightning round on 5, 6, 7, and 8.
Okay, so 5, 6, 7, and 8. Let's see, we have, what is your experience with video systems other than Zoom? And if you had to select one, which would you prefer? And 6 is, have you conducted a video arbitration where an interpreter was needed, and how did that work out? Number 7, have you conducted an arbitration where there's large amounts of documents, and how were these handled effectively? And number 8, have you conducted an arbitration that went on for multiple days, and is there anything to take away from that?
Well, the only one of those that I can comment on is that most often experiences with Zoom. I mean, I've been on conferences and conference calls with some of the other platforms like Microsoft Teams and WebEx, but Zoom seems to be the preference, the more common and the easier to use. With regard to those other issues, I haven't had any experience.
I have not had the opportunity to use an interpreter, but I don't anticipate that when that occurs, that there would be a problem.
Yeah, and as far as, you know, the largest exhibit arbitration I've had so far involved about 15 exhibits. And it was fine. I used the screen share. One thing to keep in mind, so this is a practical point that I think is helpful. Whoever is, clear your desktop, because when you do screen share on Zoom, you're going to want to clear desktop, clearly file name, save your files or exhibits, you know, exhibit 1, exhibit 2, exhibit 3. This way, when you hit share and you find the document, you could easily double click and open it up. Having a clean desktop with just your exhibits on it is going to be very helpful for doing that.
Well, thank you so much, everyone, for attending. Thank you to our panelists. It was really enlightening. I appreciate all your comments. As you know, there were Texas CLE credits obtained for this session, 1.5 hours to anyone that needs those. If you'd like to indicate that you were present, put your first and last name and the phrase, "Let's reach agreement," into the chat log, and we'll make sure that you get your CLE credits. Remember that next week we'll be meeting here at the same time, same place for session 4, the ins and outs of virtual mediation. And we certainly hope to see you back there next Wednesday. And I think that concludes our session today. Thank you so much. Bye-bye.
Bye-bye.